in your estate planning and for your family. So a lot of people tend to think about these things as they're just monetary. That's the biggest legacy that you can leave. And that's not really the case. I mean, it is certainly an aspect of it, and it can help fund your legacies that you want to leave behind, but it's not the only way to leave that legacy either. There are a lot of ways that you can leave legacies through education or charitable giving, or the messages that you want to pass on through your estate plan. So it's there's things that you can do, and some of these things you include in the documents themselves, certainly, but other things it's tools that you can use, not necessarily legal documents, but that help facilitate discussions with your family members. So welcome everybody. I'm attorney Justin Randall here with Hooper Law Office. Our topic today, as I mentioned, is 5 different ways you can leave a legacy for your family and for your loved ones, or just for causes that you care about. It is something that people often think first to money. In general, with estate planning, people tend to think about, well, it's about the money, or that's how you leave the legacy. And it always does play a factor. Money is always a factor in anybody's plan, and it's always a factor in leaving a legacy. But it is not the only thing that is involved in those legacies. There are, as with our approach to planning in general, there's a lot of things that you can do to deal with family members and charitable causes. So before I get too far in, I just want to remind everybody that if you're participating via Zoom, there is a Q&A function. So you can submit questions to me and I'll see them pop up on my screen here. So I'll try to answer them as they come up. You'll be receiving a couple materials from us afterwards if you registered in advance, our long-term care planning pyramid and our estate planning pyramid. Think of them as pyramids of the important aspects of planning, or the kind of key concepts behind why somebody would do any of these types of plans. They're really helpful, just kind of visualization tools. And if anybody has any questions at the end of this, or would like to sign up for an initial consultation with any of us, we do give out a feedback form for you to fill out that you can mark down if you would like to sign up for an initial consultation. And those are complimentary. They don't cost you anything to come in and talk to us. We like to get to know you guys before we decide what type of plan is best. So it's really helpful if you are willing to come in and talk to us. But all right. So to get started, leaving a legacy is something that a lot of people are looking to do. Not just with their own families necessarily, but for other causes as well. There are a lot of, in particular, people without any kids who want to leave a lot of legacies, through charitable giving and causes they care about. And there are a number of different ways that you can incorporate those legacies into your plan. The legal documents that you have, your will or your trust, really help you, set up the mechanisms in which that legacy will be created. But the legacies themselves come really more from you and what your wishes are. So, one of the first legacies that people think about and kind of comes to mind first and foremost is charitable giving. And charitable giving, leaving that legacy can come actually both during your lifetime and after you've passed. And it just depends on your own strategy for setting that up. So if you're really charitably inclined during life and you like to give things away during your lifetime, there's a lot of tax efficient planning that you can do with that as well. Something a lot of people are not familiar with, but is such a useful tool, is something known as a qualified charitable distribution. What that is it's where you, rather than take your required minimum distribution out of your IRA or 401k or any of those types of assets, you can directly leave that or give that distribution to a charity of your choice, or multiple charities of your choice, up to about $100,000 in any given year. So that then is completely, tax-free. Obviously, you don't have to take the required minimum out, and for your own tax purposes, and you are giving to a cause that you care about too. So that can be a really beneficial tool to actually set up those legacies while you're still alive. There are a lot of community organizations too for charitable giving that allow you to work with them. There's one here in Appleton, the Community Foundation is one. where you work with them about what your charitable wishes are and what causes you really care about, and you can set up funds with these organizations to continue on a pattern of giving after you're gone as well. So there's a lot you can do while you're living, even to set up these legacies. There are some people who don't necessarily want to leave that legacy until after they've passed. And that's where using your will or your trust, depending on what your estate plan is, that's where you can really set up those legacies there too. Some of our clients will fund one of those, kind of charitable, donor advised funds, they're called, where they're leaving money only at their death, but they're setting up sort of those charitable wishes in advance. Other people will just leave sums of money to charities that they care about too. There are also things that you can do with your family members to, kind of pass on your charitable intent. There are restrictions you can place on someone's inheritance of sort of who they're allowed to leave things to or how they can use that inheritance. So you can, in that inheritance, require that, hey, I don't care, what charities you leave things to, but you have to leave it to, a certain amount to charity, or you can put those sorts of restrictions on there. You want to be careful about doing that, obviously, and making sure that, you're putting the proper restrictions on there and you're not causing any issues with sort of like IRAs or 401ks with those inheritances. But they're working with an estate planning attorney and your financial advisor on that. That's where you can really craft a plan where you're passing on that charitable intent. So that is certainly one aspect of leaving a legacy is charitably, leaving those assets, but not everyone is as charitably inclined as others. And there's nothing necessarily wrong with that. It's just people have different wishes, right? So another sort of legacy that you can leave behind, and this one is really not a cash asset at all, but more of your own story, is sharing your life story with your family members as well. So we use a lot of tools at our firm. They're not legal documents, but allow our clients to sort of fill out very important things about their lives or their life story that they can then pass on to the next generation. How often have any of you thought about, man, I really wish I could have talked more with grandma or grandpa about, what life was like back then. I mean, this is the type of legacy that people can leave on through these stories. So this is not something that, I would draft in a will or a trust, because that's just not the place for it. And it wouldn't have any, benefit in putting it in any of those documents. So we have these separate tools that are really sheets for our clients to fill out with, prompts, things like that, interesting stories that they can tell, that really tell their future generations who they really were during life too. So legacies are also those stories that we tell to the next, or we pass on to the next generation. It gives us a way to, kind of frame who we were, and also pass on our morals and our moral legacies is probably a good way to think about it. Another legacy that people are often more concerned about is, or I guess when it comes to legacies that people tend to be more concerned about, is not being able to leave one because certain expenses during their lifetime will prevent them from doing so. And what I really mean by that is when people are mostly concerned about this is when it comes to things like long-term care expenses. So one of the biggest reasons people come in and talk to us is, I'm really worried about, the cost of long-term care. I don't know if I'll be able to afford it. I really want to leave that legacy for my family. I want to pass something on to them. I really want to make sure that they receive that from me. And that is, a completely valid concern that people have. Long-term care is very expensive. It's on average in the Appleton area, for example, not a national average, but in the Appleton area here, it can range anywhere between about $6,000 a month on the lower end to up to about $11,000 a month on the upper end. So it's really expensive, and most people in retirement don't have the type of retirement income necessary to cover these expenses out of pocket without significantly dipping into their savings, their investments, things like that. So, one of the biggest reasons, as I mentioned, people come in and talk to us is, what can I do to make sure that that doesn't happen to me, or that always the first concern of mine as the attorney is that I want to make sure that the client is well cared for, right, and has the type of care and the lifestyle that they still want to have, so that they're not down to the bare minimum at that point. But a lot of times the clients themselves are also concerned about, well, I want to leave something for my son or my daughter, or make sure my grandkids get something from me because I worked hard for this money and I want to pass it on to them. I want to give them that benefit. And that's where there are things that people can do to preserve their assets so that they don't have to spend through everything they have, just to receive care and then eventually end up on Medicaid. There are things you can do to set aside assets and protect it for the next generation, and also protect it from, in Wisconsin, what's known as a state recovery, where Medicaid will come in as a creditor for someone's estate. And if they've received any Medicaid assistance in a nursing home or an assisted living facility, they can come back against the assets that remain and potentially eat up whatever does remain. So there are a lot of planning measures that you can take to prevent that from happening and make sure that there is something left to leave to the next generation. As I mentioned, it's obviously the first concern is to make sure you're cared for. But when you then are cared for and you can guarantee you're getting the quality of life that you want in that instance, you can pass on that legacy, that, in this case, more financial legacy to the next generation. You have to do this type of planning, before it's too late, meaning before you've spent down through all of the assets, because at that point, there's no getting the money back. But there is plenty of things that you can do in advance, or even if you're going into care, immediately, that you can do to preserve that legacy for the next generation. So our next leaving a legacy, the fourth one on the list here, is making sure that you leave a legacy of education. And this can really come in a number of ways. There's obviously things like 529 plans that people set up for the next generation or for their grandkids that, can be used on qualified education expenses, usually meaning a higher level of education, like an undergrad degree or something like trade school potentially. Generally not speaking any sort of high school level expenses, although I believe there are some exceptions for certain types of private schools potentially. But those are certain types of assets that you can leave behind to help pay for that education and leave that educational legacy. There's also, leaving that educational legacy directly to the institution of your choice. A lot of people will leave money, obviously, to their alma mater or to their, to a school in their area, in order to fund a certain type of, opportunity for the next generation. I've had clients leave money behind where it was specifically intended to, give high school kids an opportunity to attend college that may have not had that opportunity otherwise, right? Or the ability to fund it anyway. So that's one way to leave a legacy, not directly to your own family, but to your community. The other sort of educational legacy that people tend to think when it comes to their own immediate family a little more about is making sure that their kids or their grandkids have the opportunity to attend a college or a trade school and make sure that they can have the best chance at success when they do so. And that often comes down to how you set up that inheritance for that individual or for that group of individuals. We will often, especially when we're dealing with minor kids, for example, if someone is leaving, I guess a sum of money to sort of be shared amongst a group of people, you can have it set up so that, especially for your kids or your grandkids, they, are all sort of sharing the pot of money until one of two things happens. Until the last one of them or the youngest one of them reaches a certain age, or until they've all graduated from college. So that until that happens, they all have the same access to that money. They're not getting individual shares that they get at different periods of time in their life. And the purpose for that type of planning, it's what's known as a common trust, sort of a pot of money in a trust, if you think about it that way. is to make sure that, regardless of what age someone is when they inherit from you, that they all have that same level of support. This is really common with parents with minor kids, for example. So the idea behind this would be if, I'm 2 years older than my brother, for example, if my parents had passed when I was 18 and had gotten all the way through high school and now was on my own for college in that instance, but my brother was 16, well, he's got 2 years less of care and support from my parents. So that would mean that I was sort of 2 years ahead monetarily too. The whole point of that sort of common trust then is there to say, well, because there's that age gap, we can make sure that the youngest sibling or the younger sibling still get that same amount of financial support from the estate that the oldest, in this case me, would have gotten it from it. And that same sort of tool can be applied to grandchildren as well, if that's what somebody wishes to happen. This becomes incredibly important if you want that same level of support for people who are, there's a big age gap in. Obviously, in my instance with my brother, 2 years is not huge, but for some people, their kids are, between the oldest and the youngest, it can be a difference of 10 years sometimes or more, right? So, if you pass when all but that youngest are adults, and now that youngest has not had anywhere near the level of financial support during their life, potentially, that the oldest did. And that's not even including sort of paying for, directly for college out of your own pocket, right? That's more just even talking about general living expenses, but it can be applied to education as well. And that's why one of those triggering events on, when that finally splits up amongst those individuals is, when the youngest of them graduates from college or reaches a certain age. Obviously, some people may never end up going to college, and that's completely fine too. It's not the choice that everyone needs to make, right? So that's one aspect as well. But the other is that the restrictions that you place on someone's inheritance, as I mentioned earlier, can really impact what your legacy is that you're leaving behind. So I mentioned earlier, you can say that they have to use it charitably, or they have to, when they pass, they have to only leave it to charities. They can't leave it to the next generation. I mean, you can put those types of restrictions on those things. But one aspect as well is to make sure that what they inherit from you, they can use for education, use for their children's education, or their own, in that, whatever the case may be. That's a really important thing to include in there if you really want them to use it for that. I mean, some people will put sort of orders of operation on what someone can use an inheritance for. Like, first, it has to be for, they can use this amount of it for education, or this amount for a down payment on a home, for example. But you can leave it more up to them too. So the sorts of restrictions that you place on people's inheritances can really dictate to them what your intent was behind it, and what your legacy, what you wanted that legacy to really be for them. And then, one of the biggest legacies, I think, that people tend to leave behind, and it's a bit more of a nebulous one. It's not, not as specific, obviously, is we really like to think of estate planning as sort of an act of love. And you're leaving that legacy of love behind for your family or the ones you care about, because by doing that planning for them, you're really taking a burden off of them in a lot of ways. As any of you who have gone through this yourself will be aware, dealing with somebody's estate when things are not properly planned, or where things are kind of all over the place, it's stressful, it's difficult, it can be costly, and to the estate, or potentially, if the beneficiaries are spending their own money on things, potentially to them as well. And so it's the best thing you can do to leave that legacy behind is to show your family that, hey, I did this planning and I made sure that you had every ounce of help I could possibly give you. And I gave you, good instructions of what to do, and how to handle the estate and what my wishes were. And so these are things like, getting a will drafted, or a trust drafted, to dictate to that next generation, here's how I want things to be handled. It can be things as simple as, making sure that you have good powers of attorney in place, right? To make sure that they can step in and help you should they need to. Um, you know, the sometimes that act of love sounds a little selfish, right? I'm letting you come in and help me, but it's the hardest thing in the world is for a family to not be able to step in and help those that they care about. So having a good financial power of attorney or a good healthcare power of attorney, so that the ones that you love can step in and help make decisions for you when you can't yourself anymore, that takes a weight off of their shoulders. Making sure that they know where everything is. Uh, and by everything, I mean documents, the legal documents themselves, where you have your financial accounts, who your advisors are, who your doctor is, where all of your records are, those sorts of pieces of information that they're going to need to properly handle things. That's really, it takes a lot of work to compile that. I mean, it's certainly not an easy thing to do, but having them be aware of those things makes it so that they have a much easier time dealing with things after you're gone or when you are incapacitated, because they know who to go talk to first. They know who handles everything, and they know exactly what the kind of clear, full picture is of the estate. I've handled estates before where somebody passed before proper planning could be done because they either hadn't done planning through us potentially, or they were trying to get in and do planning, and something unfortunate happened before they could. And in some of those cases, it's really difficult for the family members to deal with those estates because sometimes they don't know where those assets are. In some cases, it's the spouse themselves who may have not ever been the financial person in the family, especially with the one of the current generations that tends to be passing away more frequently. A lot of times it's the husband who passes first, and in a big chunk of those situations, the husband may have been the financial person in the family, the one who knew about all the accounts or handled all of those things. Certainly not in every case, but in enough of a chunk of them that it's pretty common. And I had a situation myself where a spouse basically didn't know what the financial picture was, and it took a long time to find everything and to figure out what that clear picture was. And that's stressful for the spouse too. It's stressful for the kids because they just don't know where everything is. And so if you're a spouse, one of the best acts of love you can do is, if you are the financial person, is get the other spouse involved where they can, or at least get them to the people who have that financial picture, and introduce them so they know where to look when something happens or if something happens. The other sort of act of love that you can leave through an estate plan is to make sure that your loved ones are protected from things that can happen to them in their own life. I often refer to this, and we here at Hooper Law Office often refer to this as, sort of protecting someone from sometimes themselves, but more often than not from other people as well. So this can be things like making sure that if we're talking about protecting someone from themselves, somebody who may not be financially responsible, or who has a substance abuse issue, or is maybe has a lot of creditor issues, things like that they're trying to, or they have a bad time holding on to money. They like to spend a lot of money, things like that, and find themselves with a lot of creditor issues. There are things that you can do for their inheritance that makes it so that if they are in need of protection from themselves, are not in control of that inheritance and somebody else is managing it for them. And people often think about this in particular as sort of well, that sounds harsh. That sounds like I'm not an act of love. But sometimes the biggest act of love that you can leave behind for somebody is making sure that there is something that's there to support them, right? And if somebody has trouble managing finances or has issues that would lead to them to quickly dwindle those finances, you want to make sure that you're protecting them from that, because that's really the act of love there, is making sure that there is something there to support them. And that often in those cases involves not having that person in charge of the finances that they inherit from you. You can never stop them from doing that with their own money. Obviously, that's something that they're allowed to do, but you can control what you leave them and how it can be used and who can be in charge of it. And the other protection, that sort of act of love that you're leaving behind, is protecting people from others. A big concern that people have when they come in is, how do I make sure that my children's spouses, if they get divorced, don't have access to these things? Or if somebody is in a high liability career, like a doctor or an attorney, or anything where there's hefty malpractice insurance, right? Those types of things. How do I protect them if something like that goes wrong? And the same sorts of protections that you put on those shares of an inheritance to protect somebody from themselves, can also apply to stopping creditors from forcing somebody to give up their inheritance. And it's really such a beneficial tool, because it's something that, in order for you to protect your own assets from things like that, there's some limitations on how much you can already protect, but there's also usually something you have to give up in exchange, and often that exchange is control over those assets. When you're leaving an inheritance to somebody, they can really get the best of both of those worlds, though, because if there's no reason for them not to be in control of it, they can inherit that share of the estate and be in charge of it. But should something go wrong, where they do have any issues coming up, that there's creditors or lawsuit liabilities or divorce or anything like that, they are not required to give up that inheritance for those liabilities. This obviously has to be set up properly. It's not something that, hey, I'm just leaving you a cash account of $100,000. You never have to give that to anybody. That's not how that works. I mean, so if you have this concern, you do really need to go in and talk to somebody who, ideally focuses their practice on estate planning. You don't, as with anything, you really want to go see the people who only do that area of law, because it's hard enough to be an expert on any one area of law, let alone, many. So it's a good idea to always go see someone who focuses on it. Well, with that, I'm sort of running out of time here, but I don't see any questions. So if anybody has any questions that came up from this, you can always email us at learnmore@hooperlawoffice.com. If you would like to schedule an initial consultation with any of the attorneys at our office, please feel free to fill out that form, and say that you would like to set up a time to come talk to us. Again, those are complimentary; they don't cost you anything to talk to us. And our next upcoming topic is actually, let me double check on that. All right. Oh, thank you, Nicole. Nicole, the voice in my ear told me what that next topic is. It's will my parents inherit my debt? That's an interesting topic. It can vary state by state. Or will I inherit my parents' debt too? Is another way of looking at that. Basically, can I inherit debt from somebody, or do I just get the benefit of inheriting assets? So that's an interesting topic. If that's something that concerns you or interests you at all, please feel free to sign up, the same way you signed up for this. So again, thanks for joining us, and I hope to see you guys next week.